The case of the Mihalis Angelos, 1970. In the world of international shipping and commerce generally, certainty is of paramount importance. Rising out of a contested arbitration, the case of Mihalis Angelos is a very important decision regarding contractual terms. The Mihalis Angelos was a ship owned by the claimants. It was chartered to the defendants to be used for the carrying of some cargo from Haiphong in Vietnam to Europe. Clause 1 of the charter party, the contract, the 25th of May 1965, stated that Mihalis Angelos was expected ready to load under this charter on the 1st of July 1965. The ship did not arrive by the 1st of July and the defendants cancelled the charter party. The defendants did not even have any cargo to load due to apparent complications arising from the Vietnam War. In fact, a key railway line in North Vietnam had been bombed by the Americans, which meant that no cargo could have made its way to the port in Haiphong in time for the 1st of July. What makes this case interesting is that no actual loss was suffered by the defendants, yet still they cancelled the contract, claiming a fundamental breach. The question for the court was whether or not Clause 1 of the charter party, the expected ready-to-load clause, was a condition, a warranty, or an inanimate term. If you think back to the video on Hong Kong fair shipping, you may remember that conditions and warranties can be compared to parts of a tree. Conditions, the most important terms of a contract, similar to the trunk of a tree. Warranties, the least important terms of a contract, similar to the branches of a tree. Breach of a condition entitles the innocent party to treat the contract as terminated, whereas breach of a warranty will only entitle them to claim damages, which could be less desirable. Innominate terms are where the court looks to the effect of the breach, see Hong Kong fair shipping and Kawasaki Kaizen Kaisha. In the Mihalis Angelos, it was held by the court, with Lord Denning dissenting, that the expected ready-to-load clause, Clause 1, was a condition, and that the defendants were entitled to cancel their contract with the claimants. The essential reason for the decision was commercial certainty. Lord Justice McGaw: in my judgment, such a term in a charter party ought to be regarded as being a condition of the contract. One of the essential elements of law is some measure of uniformity. One of the important elements of the law is predictability. At any rate, in commercial law, there are obvious and substantial advantages in having, where possible, a firm and definite rule for a particular class of legal relationship. It is surely much better, both for ship owners and charterers, and incidentally, for their advisors, when a contractual obligation of this nature is under consideration, and still more when they are faced with the necessity for an urgent decision as to the effects of a suspected breach of it, to be able to say categorically, if a breach is proved, then the charterer can put an end to the contract, rather than that they should be left to ponder whether or not the courts would be likely, in a particular case, when the evidence has been heard, to decide that in the particular circumstances, breach was or was not such as to go to the root of the contract. Where justice does not require greater flexibility, there is everything to be said for, and nothing against, a degree of rigidity in legal principle.